All right, so looks like we're talking eviction defense in Southern California. Definitely a topic you don't want to have to learn about the hard way. But no worries, we're going to break down the essentials so you're not caught off guard.
Right. We're going to unpack the complexities of the eviction process, all the local ordinances, and most importantly, highlight those crucial first steps you need to take if you ever find yourself facing that eviction notice.
Yeah, so let's just say the dreaded notice arrives. What's the absolute first thing that someone should do? I'm guessing it's not just like panic, Googling eviction help.
Definitely not. While the internet can be helpful, your priority should be seeking legal counsel immediately. And I know it sounds dramatic, but the clock starts ticking the second that notice hits your hands. You have a 5-day response time in most cases.
5 days?
Yeah.
That is not a lot of time to like wrap your head around all the legal jargon and figure out your next move.
Yeah. Exactly, and that's why organizations like the Martinez Law Center and the Legal Aid Foundation of Los Angeles, or LSFLA, are so vital. They can help you decode that notice, understand your rights, and figure out the best course of action.
So they're like the first responders of the tenant world. You call them when the alarm bells are going off.
That's a great analogy. They can really help you navigate the complexities of just cause eviction and make sure you're not being unfairly targeted.
Okay, just cause. That sounds pretty straightforward. But I have a feeling there's more to it than meets the eye.
You're right. While things like missed rent or lease violations are common grounds for eviction, there are nuances. For instance, you often have a right to cure a violation. Let's say your lease prohibits pets, but you got a puppy without realizing it. Curing the violation might involve proving the dog is vaccinated and doesn't cause any disturbance.
Also, it's not an automatic out for the landlord. You can potentially rectify the situation.
Exactly. And on the flip side, if you're being evicted for something minor, while your landlord is ignoring a major repair that's a red flag, landlords have a legal obligation to maintain habitable living conditions.
So if the landlord's neglecting their responsibility, that strengthens your position. That feels like a pretty crucial piece of the puzzle.
Absolutely. It's all about knowing your rights and recognizing when they're being violated. And speaking of protecting yourself, let's talk about documentation.
Okay, I'm sensing this is where things get really important. We're not just talking about like keeping track of rent receipts, right?
Right. While rent receipts are essential, think of documentation as building a fortress around your case. Your lease agreement, any communication with your landlord, emails, texts, voicemails, photos or videos of needed repairs, everything. It's all potential evidence.
Wow. It's like every piece of paper, every text message could become like a weapon in your arsenal.
That's a great way to put it. Imagine a scenario where your landlord claims you damaged the property, but you have dated photos proving the damage existed before you moved in. That's the power of documentation. It protects you from false accusations and strengthens your position.
Yeah, this is making me want to go back and like meticulously organize all my landlord communication. It's amazing how these seemingly small details can make such a big difference.
It really can. The Martinez Law Center even emphasizes the importance of creating a comprehensive documentation trail to solidify your case.
Yeah.
They can guide you on what to prioritize and how to organize it effectively.
So even if you're not officially in like eviction mode, having this system in place is like a preemptive strike. It helps you be prepared just in case.
Exactly. It shifts the power dynamic. Landlords might be less likely to try anything shady if they know you're meticulous about documenting everything.
Okay, so we've got finding legal help, ASAP, understanding just cause, and building that documentation fortress. What else should someone do in those crucial first 5 days after receiving an eviction notice?
This is where understanding the unlawful detainer process itself becomes crucial. You have a very limited window to respond to that lawsuit and present your defense. Miss that deadline, and you risk a default judgment, meaning you could be evicted without even getting a chance to argue your case.
Wow. So even if you have like a rock-solid defense, missing that deadline can be fatal to your case. I'm starting to see why you emphasize legal counsel right from the beginning.
Absolutely. This is where organizations like LAFLA, which are contracted by the city's Eviction Defense Program, or EDPs, step in. They analyze the eviction notice, help you prepare a legal defense, and even represent you in court if necessary.
So it's not just about giving advice. They're literally fighting alongside you.
They are, and it's crucial to understand that eviction laws can vary depending on your location. Local ordinances in places like Orange County, Los Angeles, Riverside, and San Diego can offer additional protections.
Okay, so let's say I'm like in Santa Monica. Are those local nuances going to change things for me?
They absolutely could. For example, Los Angeles declared an emergency declaration in response to COVID-19, which impacted rent deferral policies. However, remember, things are constantly evolving, so finding the most up-to-date information for your specific city is crucial.
So even if you think you know the general rules, it's essential to double-check what applies in your city. It's like playing a game where the rules keep changing mid-game.
That's a perfect analogy. And that's where a website like Stayhouse LA can be invaluable. They provide an updated list of rent stabilization and just cause ordinances for different cities in Southern California.
All right, so we've got legal help documentation, understanding local ordinances, and that 5-day response deadline. What else should someone be thinking about during this initial phase?
Well, while tackling legal aspects is critical, remember that eviction is often a symptom of a larger financial struggle. Don't overlook resources like rental assistance programs, which can help address the root cause of the problem. LAFLA, through the EDP, can help connect you with those resources as well.
That's a great point. It's not just about winning the legal battle, but also about finding a path to stable housing in the long run.
Exactly. It's about approaching the situation holistically and addressing both the immediate crisis and the underlying challenges.
Okay, so we've covered a lot of ground here. Legal aid documentation, local ordinances, rental assistance, all crucial components in those critical first 5 days. It feels like we've just laid the groundwork, though there's still so much more to explore, right?
Absolutely. We've just scratched the surface. In the next part of our deep dive, we'll delve deeper into specific legal defenses, how to navigate the unlawful detainer process, and most importantly, how to advocate for yourself effectively.
Yeah, I'm already feeling more informed and slightly terrified by how much I didn't know. But it's empowering to have this knowledge. I can see why you said those first steps are so vital. They can literally make or break your case.
They can. And that's why we emphasize seeking legal help early on. It's like having a skilled guide to help you navigate a complex and often treacherous terrain.
Great analogy. Okay, so before we move on to part 2, any final thoughts for our listener as they process all this information?
Just this. Don't let the complexity of the process overwhelm you. Take it one step at a time. Prioritize finding legal assistance. And remember that you have rights. You don't have to face this alone.
All right, on that empowering note, let's take a quick break and come back for part 2, where we'll dive deeper into those legal defenses and the ins and outs of the unlawful detainer process.
Okay, so we're back, and I'm ready to delve into those legal defenses you mentioned. It feels like we're about to equip ourselves the whole arsenal of strategies here.
That's a great way to look at it. Remember, even when a landlord has just cause, it doesn't mean they've automatically won. Let's unpack some common defense strategies.
Yeah. Hit me with the legal knowledge.
Well, we talked about how even small errors in an eviction notice can get it tossed out. But beyond technicalities, one powerful defense is the breach of warranty of habitability.
And we touched on the landlord's responsibility to provide a livable space, right? Yes, this defense hinges on that. It basically argues that the landlord failed to maintain those habitable conditions, rendering the unit unlivable. Think persistent leaks, faulty plumbing infestations, anything posing a health or safety hazard.
So let's say a landlord tries to evict for late rent, but they've ignored multiple requests to fix a broken heater in the dead of winter. That could be a valid defense.
Exactly. It's saying, hey, I might be behind on rent, but you haven't held up your end of the bargain either. Courts often take this defense very seriously, especially if you can prove you notified the landlord and they failed to take action.
That makes sense. It's not just about who's right or wrong, but whether both parties fulfill their obligations. What are some other defense strategies?
Another big one is discriminatory or retaliatory eviction. Landlords can't evict you based on protected characteristics like race, religion, gender identity, disability, etc. They also can't retaliate if you exercise your rights like requesting repairs.
So if I complain about a safety hazard, and suddenly my landlord wants to evict me for like an unrelated minor lease violation, that raises red flags, right?
Absolutely. That's a classic example of retaliatory eviction, and it's illegal. It's crucial to document everything in these situations. To establish a clear timeline of events, remember those text messages we talked about? They could be your saving grace here.
Okay, so we've got breach of habitability, discriminatory or retaliatory eviction. Any other defense aces up our sleeve?
Well, there are also procedural defects. These are mistakes the landlord makes in the legal paperwork or process. Think serving the notice improperly or filing the lawsuit incorrectly. Even typos can sometimes lead to dismissal or delays.
It's fascinating how these seemingly minor details can have such a huge impact on the outcome. It really highlights the importance of having someone knowledgeable on your side scrutinizing every step.
You're spot on. That's why those free legal consultations are so invaluable. Organizations like LAFLA, through their work with the city's EDP, have experts who can spot these procedural errors and use them to your advantage.
Okay, so let's say we've identified our defense strategy. What happens next in this unlawful detainer saga? Walk me through the process.
Well, after that initial 5-day response window, things move quickly. If you don't respond, you risk a default judgment, and that's usually the end of the road. But if you filed your response, the case proceeds to the discovery phase.
Discovery? That sounds intense. What exactly goes down during this phase?
It's basically information gathering. Both sides exchange documents and evidence to support their claims. This is where that meticulous documentation you've been diligently compiling comes into play.
So all that effort wasn't just for show. It's like preparing for a legal showdown, making sure you have all your ammo ready.
Precisely. Having solid documentation can make or break your case during discovery.
So we've got the response to the discovery phase. What's next? Is it finally time for the dramatic courtroom showdown?
Well, before we get to the courtroom, there's usually a chance for mediation. This involves a neutral third party who tries to help both sides reach a settlement. It's a way to potentially resolve the issue without going to trial.
So it's like a let's try to work this out like adults moment before things escalate further.
Yeah. Exactly. And it can be incredibly effective. Often a compromise can be reached that benefits both parties.
That sounds promising. But let's say mediation fails and we are heading to court. What can someone expect during a typical eviction trial?
The trial itself is where you present your defense, using evidence and legal arguments. Having legal representation at this stage is absolutely crucial. Organizations like LFLLA, through their EDP involvement, can provide experienced attorneys who understand the nuances of these cases.
So it's like having a seasoned warrior fighting alongside you in the legal arena.
That's a great analogy. They know how to present your case, effectively challenge the landlord's claims, and advocate for your rights.
Okay, so we've gone through the response, discovery, mediation, and trial. What happens if the court rules against you? Is it game over at that point?
Not necessarily. Depending on the circumstances, there might be grounds for an appeal, but that's a whole other legal battle. And it's best to consult with your attorney to determine if it's a viable option.
Okay, so even in a worst-case scenario, there might still be some recourse. That's a glimmer of hope, even though I'm sure it's not an ideal situation.
You're right, it's not ideal. But it's important to remember that even facing an eviction lawsuit, you still have options and potential avenues to explore.
I'm starting to see how understanding this process can help someone feel more in control, even when facing such a daunting situation.
Absolutely. Knowledge is power. The more you understand the legal landscape, the better equipped you are to navigate it effectively.
This has been incredibly insightful. We've covered so much ground from those crucial first steps to understanding the various defenses and the unlawful detainer process itself. Before we move on, any key takeaways you want to reiterate for our listener?
Just this. If you find yourself facing an eviction notice, don't panic. Remember, you have rights. Seek legal help, immediately document everything, and don't be afraid to fight for your home.
Solid advice. And I think what's really resonating with me is how crucial those legal aid organizations are. They're like the superheroes of the tenant world, coming to the rescue when things get tough.
You're absolutely right. They level the playing field and ensure that everyone, regardless of income, has access to justice.
Okay, on that empowering note, let's take a moment to regroup, and then we'll dive into some additional resources and final tips in part 3. Okay, so we've unpacked like a ton of information about eviction defense. From those crucial first steps to navigating the unlawful detainer process, it's clear that knowledge is a tenant's best weapon in these situations.
Absolutely. And there's one more powerful tool we haven't explored in depth yet: proactive planning. It's not just about reacting to an eviction notice. It's about taking steps to protect yourself before you ever reach that point.
Okay, I'm intrigued. What does proactive planning look like in the world of tenant rights?
Well, it starts with knowing your lease inside and out. Don't just skim it. Study it. Understand your rights and responsibilities as well as the landlord's obligations. Pay close attention to clauses about rent increases, repairs, and grounds for eviction.
So it's like studying for a test, except the test could determine whether you keep your home.
That's a great way to put it. And speaking of tests, regularly inspect your unit for any potential problems. Document any existing damage or repairs needed when you first move in. This establishes a baseline and protects you from being blamed for pre-existing issues.
That's smart. It's like creating a before picture, so you can prove what condition the unit was in when you arrived.
Exactly. And when it comes to repairs, always communicate with your landlord in writing. This creates a paper trail, documenting your requests and their responses. or lack thereof. Remember those emails and text messages. They can be crucial evidence later on.
Okay, so knowing your lease, documenting existing damage, and communicating in writing, that's a solid foundation for proactive planning. What else can tenants do to stay ahead of the game?
Stay informed about your local ordinances. Websites like Stay Housed LA provide a wealth of information on tenant rights specific to your city. Knowing those extra layers of protection can be a real game changer.
Right, even within Southern California. The rules can vary significantly depending on your location.
They can. And don't underestimate the power of community. Connect with other tenants in your building or neighborhood. Sharing information and experiences can empower you and create a sense of solidarity.
Yeah, it's so important. It's easy to feel isolated and powerless when facing these challenges. Knowing you're not alone can make a huge difference.
Absolutely. And remember, knowledge is not just power, it's peace of mind. The more you understand your rights and how to protect yourself, the less daunting this whole process becomes.
I love that. It's about shifting from a place of fear and uncertainty to one of confidence and preparedness. It's like having a shield to deflect those landlord anxieties.
Exactly. And remember, even if you never face an eviction notice, this knowledge is invaluable. It empowers you to advocate for yourself, communicate effectively with your landlord, and create a more positive and stable housing experience.
All right, I'm feeling inspired and ready to tackle any landlord-tenant challenge that comes my way. Before we wrap up this deep dive, is there anything else you want to emphasize for our listeners?
Just this. Don't let the complexity of the process intimidate you. Break it down, step by step. Prioritize finding legal assistance. And remember, those amazing organizations like the Martinez Law Center and LAFLA, they're there to support you every step of the way.
Yes, reach out to those legal superheroes. They're your allies in this journey. And remember, knowledge is your most powerful tool. The more you understand your rights and resources, the better equipped you are to navigate the often challenging world of tenant rights.
That's right. And remember, even if your specific situation isn't covered here, the underlying principles remain the same. Seek expert advice, understand your rights, and be proactive. You've got this.
Okay, folks, that concludes our deep dive into eviction defense in Southern California. We hope you found this information empowering, insightful, and maybe even a little bit inspiring. Remember, you're not alone in this journey. Arm yourself with knowledge, connect with those incredible resources we've discussed, and most importantly, don't give up.
Thanks for joining us.
And remember, happy renting.
Call now 714-442-9741. Thank you.